In this lecture, we're going to talk about the Inter-American system, which is one of several regional systems that exist independently of the United Nations system. The Inter-American system is the system in which Canada and the United States are active participants, as are all of the other states of the Western Hemisphere, with one exception, as we'll see. And it is also an important venue for the prosecution of indigenous rights, at least for indigenous peoples who live within the Americas. It's also a good model for the way that other regional systems in areas of the world within indigenous peoples operate. So we're going to spend some time looking at it in detail. Origins. The first Inter-American system arose out of a meeting in 1889 to 90, held in Washington, D.C., which was called the First International Conference of American States. At that event, 18 states agreed to form collectively the International Union of American Republics with a secretariat, which is to say an administrative office, as we know, called the Commercial Bureau of the American Republics. At the Fourth International Conference of this organization, which was held in Buenos Aires, Argentina in 1910, they made a name change. The International Union changed its name to the Union of American Republics, and the Secretariat was renamed the Pan American Union, a name which would last for some time. The Pan American Union building, which was the Secretariat headquarters, was constructed in Washington, D.C. In 1910, and it's the current headquarters of the Organization of American States. Now, at the Ninth International Conference of the American States, held in Bogota in 1948, 21 states decided to reorganize again, signing a new charter for a new entity to be called the Organization of American States. So it's to that Ninth International Conference that the OAS traces its origins, and the charter went into effect in December 1951. So the Organization of American States is a mid-20th century entity. And it's created somewhat along the same lines, or it operates somewhat along the same lines as the United Nations system. There are two principal political bodies with which you'll want to be familiar. The first is the Permanent Council, and the second is the General Assembly. The Permanent Council is composed of ambassadors appointed by the member states of the OAS, one per state, and they meet several times a month at the OAS headquarters in Washington, D.C. The Permanent Council is responsible for directing the organization's day-to-day activities. And in a sense, it's like a secretariat, but maybe more so, because as you'll see, there's more that they're responsible for. The General Assembly is the supreme decision-making body in the OAS system, but it doesn't meet very often. It might best be analogized to a board of directors for a corporation, which comes in, sees the work product that the Permanent Council has produced, and then approves it or not. So this would include budgets. The General Assembly convenes, approves a budget, approves reports, issues declarations and resolutions setting policies, this sort of thing. They meet once a year for periods of a couple days to a couple weeks, but never more than that. And their place of meeting moves around the hemisphere. So every year they'll be at a different city in a different member state. As noted in a previous lecture, all states in the Western Hemisphere are members of the OAS system. The only exception to active membership is Cuba. Cuba is officially a member, but their membership was suspended in 1962 In 2009, the OAS invited Cuba to rejoin as an active member, but Cuba has declined to do so. The Inter-American Human Rights System, which is the system within the OAS most used by indigenous rights advocates, was created in 1948 at the same conference that created the Organization of American States, with the adoption of the American Declaration on the Rights and Duties of Man, which was a rights declaration, it's aspirational, actually adopted by an international organization just before the UN adopted its Universal Declaration of Human Rights. And that American Declaration is the source of the rights exercised by indigenous peoples to this day within the Inter-American Human Rights System. It's one of the sources. In 1959, the OAS created the Inter-American Commission on Human Rights, or IACHR in its English acronym, which was to be based in Washington, D.C., and the commission then became the principal entity for the receiving and resolution of human rights complaints throughout the hemisphere, including by indigenous peoples. In 1965, the commission was authorized to examine specific cases of human rights violations brought to its attention by individual petition. That was a huge development. That was the point at which individuals who felt their rights had been violated by their state could suddenly appeal to an international forum. And that's that petition mechanism, which we're going to talk about in detail later in this lecture, will become the vehicle for the protection of indigenous rights within the Inter-American system, the primary vehicle. Since then, the Commission has received thousands of petitions, and it's a major component of the work that the commissioners actually do. In 1969, the American Declaration was supplemented by the American Convention on Human Rights. That, of course, is a treaty, which means it creates a method for enforcement and it creates binding obligations on all of its signatories. The enforcement entity created within the American Convention was the Inter-American Court of Human Rights, about which again we'll speak later. The convention entered into force in 1978, and the court was established in 1979 in San Jose, Costa Rica. In 1989, the OAS asked the Inter-American Commission on Human Rights to prepare an instrument on the rights of indigenous populations. The IACHR, with input from governments, indigenous organizations, and others, drafted a proposed American Declaration on the rights of indigenous peoples, which was submitted to the General Assembly in March 1997. It was a comprehensive document that mirrored in some important respects the UN Declaration on the Rights of Indigenous Peoples that was at the same time being negotiated in Geneva. In June 1999, the General Assembly of the OAS established a working group of the Permanent Council to develop the draft, which is to say, as in Geneva, now in Washington, and as it happened elsewhere, state delegations were getting together to talk about what the various articles should mean. Unlike the UN Declaration, which was adopted, finished in negotiation and then adopted by the General Assembly of the UN in September 2007, the draft American Declaration is still a draft declaration. It's still in process of negotiation by the working group. I'm going to talk a little bit more about that process in the last lecture for the course, but note now that it's a process that, like the UN process, includes indigenous representatives, not in voting, but in discussion over what the various articles should say. The principal mechanism used by indigenous peoples, as I've suggested, in the OAS system is the Inter-American Commission on Human Rights, the IACHR. So what is the Commission? Well, it's not large. The Commission has 7 members elected by the General Assembly from a list of candidates submitted by member state governments. Commissioners hold their offices for 4 years, and their responsibilities are fairly extensive. They have to evaluate petitions, as we'll see, and they have to engage in research efforts as rapporteurs. Those are their principal responsibilities. In addition to that, there's preparation of reports, et cetera. So the 2 responsibilities we'll focus on will be petitions and rapporteurships. Let's start with rapporteurships. There are a number of rapporteurships in the Inter-American Human Rights System. Some are thematic, and some are country-specific. So you might, and they're divided up among the commissioners. So you might be the rapporteur responsible for a number of states, including, say, Argentina and Colombia and maybe Canada, although not exactly divided along those lines. Plus, you'd have some thematic rapporteurship responsibilities, including, since 1990, you might be the rapporteur on the rights of indigenous peoples. That's the rapporteurship that, of course, will be of greatest interest to us, and it parallels the position of special rapporteur on the rights of indigenous peoples created within the UN system. But rather than being held by an independent expert in the OAS system, it's held by a member of the Inter-American Human Rights Commission. The responsibilities of the rapporteur on the rights of indigenous peoples in the OAS system include researching, traveling to states, meeting with governments, meeting with indigenous leaders, and then reporting on the extent to which the rights of those indigenous peoples are being respected within member states. And as in the UN system, getting to know the rapporteur can be useful for indigenous rights advocates. If the rapporteur comes to your state, to your country, to your member state in the OAS system, schedule a meeting. See if you can talk to them about the issues facing your communities. Petitions, which is the other of the largest areas, perhaps the largest time consumer for commissioners, can be filed by anyone, including tribes, including indigenous governments, also including individuals. And the defendant in the petition would be a state, and the allegation would be that the state has violated the human rights of the petitioner as defined and protected under an international rights instrument to which the member state is a signatory. Now, for all of the OAS members, this would include the American Declaration on the Rights and Duties of Man. For some of the OAS member states, this would include one of a series of conventions. And the convention of greatest importance to indigenous peoples is the American Convention on Human Rights, which was the second major human rights document. But there are other human rights treaties. There's one on torture, there's one on the death penalty, et cetera, which may come into play for indigenous advocates. But the 2 principal instruments that form the basis of petitions are the American Declaration and the American Convention, and that's how I'm going to refer to them. Most member states have ratified the American Convention, but there are 2 important exceptions. One is the US, and the other is Canada. So petitions cannot be filed with the Inter-American Commission against the US or Canada alleging violations of the American Convention, because neither of those states, again, is a party to that convention. Violations, assuming that you do have party to the convention, or violations under the declaration, which can be raised against all, include acts of commission, so the state has actually affirmatively done something to violate your rights, acts of omission, meaning that the state has sat back and allowed your rights to be violated, and acts of acquiescence, which is to say the state has affirmatively consented to the violation of your rights by another entity. Before one can file a petition with the Commission, domestic judicial remedies have to be exhausted. What this means is if your rights are violated one day, you can't file a petition with the Inter-American Commission the next day. You actually have to complain through your local court system. And you have to carry that process to its end, which in most states would mean losing at trial and then losing on appeal all the way through whatever the highest level of appeal in your system is. Once that's happened, there's no more relief that you can have in your domestic judicial system. If you still feel your rights have been violated, at that point you can file a petition with the Inter-American Commission. Now, this is called the exhaustion requirement, and there are exceptions to it. Certain instances, and the Commission will say, well, go ahead and file your petition anyway. We get that you can't exhaust. It's unfair to expect you to exhaust. These would include cases of denial of access, where you tried to complain in your domestic judicial system, but they wouldn't let you for some reason. Or if the judicial system affords no due process rights, so it's an unfair proceeding, then the Commission isn't going to require you to exhaust. Or if there's delay in the issuance of a final opinion with no valid reason, and this can happen because states understand that there's an exhaustion requirement, so you might file your final appeal and the state doesn't want this to become an international incident, which it would by the filing of your petition with the Inter-American Commission, so they just decline to ever issue any opinion at all. And sit on it for however long they want to. If that's what's happened to you, then you can go ahead and file and just explain that you're never going to get an opinion because they're trying to defeat the petition process, and that's okay. The filing of the petition has to occur within 6 months of the issuance of the final decision. That's your limitations period, as we'd say. Or if you're operating under one of the exceptions, then it has to be filed within a reasonable time of your becoming aware that you weren't going to get resolution, assuming that you fall under one of the exceptions. You don't have to have a lawyer to file one of these, and commonly individuals will file on their own behalf. Forms are provided by the Commission. You can locate these online that tell you what information they need and in what order. And there's no filing fee. So there's no cost to you as a litigant to file these things. And lastly, they can be filed by email. So you can get the form, type it up, send it in by email. There's no more formality required than that. It's an fairly informal and inexpensive process, and that's, of course, by design. Now, once the Commission receives your petition, they will conduct a preliminary evaluation and make a decision about what to do with it. And they've really got 3 options at this point. They could decide not to process it because you failed in some way to comply with the requirements. You didn't exhaust, and you're subject to none of the exceptions. So that would result in a decision not to process it. Keep going, and eventually maybe after you've exhausted, we'd be happy to hear this. They could request more information if the form isn't fully completed or they're not sure they understand exactly where it stands in the domestic system. Or they could open it for processing. And that's where they're satisfied that you've complied with all the requirements, you've filled out all the information you need to on the form, and you have exhausted your local remedies. And at that point, or at least preliminarily it appears that you have, at that point the petition enters what's called the admissibility stage. In the admissibility stage, the petition is sent to the state for some response. And this is often or usually the first time the state will see this petition. The state has the opportunity to reply. The Commission may ask them for more information. or they may ask the petitioner for more information in response to something that the state has said. And ultimately, after they've got all the information they need, the commission will decide whether the petition is admissible. And the usual ground for non-admissibility is failure to exhaust. If it's not admissible, then they send it back and they say try again once you've exhausted, because after we've heard from the state, we get that you really haven't exhausted, though we understand you thought you had. But if it is admissible, then they'll go ahead and analyze it and make a decision. They'll analyze the allegations. They might request more information from you. They might request more information from the state. They'll likely attempt to encourage a settlement between you and the state. If that's not possible, then they'll issue a decision. The decision will take the form of a report that the commission will issue and serve on the petitioner and on the state. It's a report on the merits. It will include the commission's findings based on the factual report submitted to it. And it will include the commission's recommendations. And that's an important point. All the commission's empowered to do is make recommendations at this stage. And the recommendations may or may not be followed, and there may or may not be consequences to that, as we'll see momentarily. The recommendations will often include some combination of the following. One is a cut it out order or suggestion. A recommendation, if there's a finding that there has been a violation, then the first thing that the commission would likely recommend to the state is that they stop violating the human rights of the petitioner. They also commonly include recommendations that the state investigate the violation and impose sanctions internally. So figure out who it is in, say, hypothetically, your police force who's been violating this person's or this group's rights, and then do something about it, discipline them in some way. And of course, the state does have the power to impose sanctions, even though the commission itself doesn't. Often, the commission will recommend the paying of reparations to the petitioner. Give them money or some other form of compensation if there's been a human rights violation. Give them the job they were applying for that they were unfairly denied. Sometimes there will be a recommendation that laws be changed. So if the statute that the state has that's made possible the violation, the commission would likely recommend that the statute be repealed or amended to eliminate the possibility that other violations will occur in the future. If the state doesn't comply with the recommendations, the commission has a couple options. One is to publish the case. Now, at this point, the copies of the report have been served on the parties, but if there's and it may end then, but if there's non-compliance, then the commission can publish its report more broadly. And this can be an effective sanction. This is the international shaming that we saw when we talked about treaty bodies that can be effective. It provides advocates with public relations tools. Here, the Inter-American Human Rights Commission on Human Rights has found that the state violated the human rights of this indigenous group, for instance. And so this isn't a meaningless exercise, this further publication. And that's one thing the commission will almost certainly do. The other is, in certain instances, the case can be referred to the court. And this is the Human Rights Court, Inter-American Court of Human Rights that meets in Costa Rica, that was established under the American Convention. But they can only do so, because it's an American Convention court, if the basis for the violation is a right protected under the American Convention. So a petitioner makes a number of allegations, violation of the American Declaration and violation of the American Convention. If the commission finds there has been a violation of the American Convention and the state declines to follow its recommendations to fix the problem, then they can refer the case to the Inter-American Court, which does have enforcement power, at least vis-a-vis violations of the American Convention. Now, the limitations will be obvious. The principal limitation to this remedy of referral to the court is that the only states subject to having charges against them referred to the court are states that have accepted the jurisdiction of the court, states that are signatories to the American Convention. And if you're not a signatory to the American Convention, then by definition you're not subject to the jurisdiction of the court, and that means that if a petition is filed against you, recommendations are made, you don't comply with them, publication is the only option for the Commission. They can't refer the case to the court for a judgment against you that would be enforceable, appreciate, because we're talking about a convention again. Most of the member states of the OAS are subject to the jurisdiction of the Inter-American Court, but there are two important exceptions, the United States and Canada. So if you're an indigenous group and you file a petition against either of those states with the Commission, the most you can hope for would be a favorable result in the Commission and recommendations for maybe reparations, changes in law, etc., with which the state would then decide to comply. But if they don't, then publication by the Commission is really your only avenue for relief. On the other hand, if you're an indigenous people or individual in one of the states that are subject to the court's jurisdiction, then if you succeed before the Commission and the state doesn't comply with their recommendations, you can ask that your case be referred to the court, and the court will again revisit the case on the merits. It's a much more judicial process, and they will issue an order to which the state will be subject. One final note on this process, and then we're going to look at a couple case studies, is that if you are in an emergency situation, there is a process, the details of which we won't discuss, but be aware that there is this process for the Commission to take precautionary measures, which are in a U.S. and other sort of legal context similar to preliminary injunctions. So the Commission will say basically, we aren't really sure how this is going to turn out, but this is especially egregious, so if you're doing any of this, you have to stop it now, please, or they'll make that recommendation. That would be the precautionary measure. I want to conclude by looking at two case studies. The first of these is the case of the Awastigni, and the second is the case of the Dan sisters. So, Awastigni, a little background. The Mayagna community of Awastigni is a Nicaraguan indigenous community. They sued Nicaragua in 1995, alleging that their rights to ownership of their traditional lands and natural resources had been violated when Nicaragua granted logging concessions to non-indigenous entities on their lands without their consent. In 1998, after they had exhausted domestic judicial remedies, they had petitioned the Commission. The Commission found in 1998, among other things, that Nicaragua had violated the right to property protected under Article 21 of the American Convention, to which Nicaragua is a party. Nicaragua's reply to the recommendations that the Commission made at that point was unsatisfactory to the Commission. So the Commission referred the case to the Inter-American Court in 1998. The court affirmed the Commission's findings in 2001, agreeing that there had been a violation, among other things, of Article 21 of the American Convention. and ordered Nicaragua to survey the lands of the Awastigni and title the land to the Mayagna community. And Nicaragua began what has turned out to be a very long period of attempting to comply with that order. So that's an instance, an illustration of how the process works with the two entities that ultimately resulted in an order from the court that was inconsistent with what Nicaragua's domestic courts had done, but which worked to the advantage of the affected indigenous community. The Dan sisters case involves a petition filed against the United States in the Inter-American Commission. It's the case of the Western Shoshone, and the Dan sisters, Mary and Carrie Dan, were ranchers. They claimed that certain lands were Western Shoshone lands. The U.S. judicial system disagreed on the basis that in the old Indian Claims Commission, the government recognized by the U.S. as the government of the Western Shoshone Nation had accepted or had received compensation for the lands that the Dan sisters claimed. The Dan sisters claimed in the domestic process, for a variety of reasons, that was legally ineffectual. And once they had lost in the U.S. legal system, their attorneys filed with the Inter-American Commission. Let me say a word about the lawyers for the Dan sisters. They were represented before the commission by the Indian Law Resource Center, which is based in Washington, D.C. and Helena, Montana, along with the International Indian Treaty Council, which I mentioned in an earlier lecture. They are the principal advocacy entity in the U.S. For indigenous groups within the international system. They're prime players, very active players, as is the IITC and the OAS system, and also were instrumental in the adoption of the UN DRIP in the UN system. And they're a group that you want to be aware of. So, the Dan sisters filed this petition. The allegation was that the U.S. had violated, among other things, Article 23 of the American Declaration, which protects land rights. They didn't file any claims under the American Convention, of course, because the U.S. isn't a party to the American Convention. They challenged the legality of the Indian Claims Commission award and were successful in 2001 at winning a report from the Commission finding against the U.S. The report included recommendations that the U.S. provide the Dan sisters an effective remedy to ensure their right to property is protected under the American Declaration, and a recommendation that the U.S. review its laws in order to better protect indigenous land rights as required by the Declaration. And there has been no U.S. response, so there's been publication. And it's a case that you may have heard of. Now, one note about the Dan sisters case, one of the interesting features of the report is that in the course of argument, the Indian Law Resource Center alleged, in addition to violations of the American Declaration, violations of principles enshrined in the draft American Declaration on the Rights of Indigenous Peoples, which again is still not a ratified or adopted document within the OAS system, and at the time was in process of negotiation. And the Commission, in its report, actually took those arguments and made reference to them, which created the impression that it's fair to cite to the draft American Declaration in making argument in petitions before the Commission. And that's something, it's a precedent of a sort. It wasn't relied upon by the Commission, at least overtly in the decision. It didn't find violations of the draft Declaration. But it's an important practice point, I think, that even though that document has not yet been finalized, it's apparently available as a source of argument, of principles, of ideals, or something. After the Dan sisters' decision, and this is the final point I want to make, and then we'll close this lecture, the attorneys made use of the published report, but they didn't stop advocating. Instead, they started looking elsewhere in the international system. And here's the marriage of the inter-American system and the UN system. We next see the Dan sisters filing a report with the CERD, the Committee on the Elimination of Racial Discrimination, about which we talked in an earlier lecture. Which is to say, if you're an advocate within the international system, it's important to understand how the regional system works and the UN system works, but also to be aware that you can make use of both of these in advocating for the interests of the indigenous people whom you represent. The lesson to take from this, I think, is that when advocating for indigenous peoples within the international system, it's fair to take advantage both of the regional system and the United Nations system. And if you're going to be a successful advocate for your community, you'll want to be aware of how both of those processes work.